We got a special treat coming up. We have an interview with Victor Forberger. Um, he is an attorney from Wisconsin. He'll tell you all about what he does, but he specializes, among other things, in unemployment. So we're going to have a really good talk about unemployment. And when I say he's from Wisconsin, what I mean he practices in Wisconsin. I believe he says he's from Boston. So I think one of the things that makes his insight so valuable is he's able to look at Wisconsin from an outside lens. So that this is going to be, I think, a pretty amazing interview here. Yeah, I have almost no idea what I'm doing, including running OBS. So, of course, I'm turned down some setting and you can barely hear what I have to say. Luckily, it's not that great anyway. What Mr. Forberger has to say really is going to knock your socks off in terms of what is the state of unemployment sort of in the bureaucracy and why there's all this money sitting here in a supposedly insurance program available for everybody to use. So we're going to break this down. I think it was 40 minutes, almost 15 minutes. We're going to break it down into two parts here. There's something else I really want to add, and this is pretty much the first time that I've ever seen Mr. Forberger, over Zoom. We have corresponded a few times in various endeavors, we'll say, and I'll reveal that what we're doing, our other work together. It's not for clients, but for greater good purposes. We'll talk about that some other time. What I do want to say is, I think that there's a real connection here because Mr. Forberger, and I think like many of you, refuses to believe that these bureaucrats are as stupid as that they would have us believe. And I think that is something that's pretty amazing here. We have a few attorneys in this world that really are willing to put it all on the line, and I think Mr. Forberger is going to explain to you just how he does it. He is on the vanguard, on the forefront, the tip of the spear, as it were, of pushing forward vital issues for unemployment in Wisconsin that need to be dealt with. And he and I are going to cross over in terms of what I'm doing with equal rights and the ALJs there and the due process stuff that you and I have all been looking at recently, and what he's doing with unemployment, which is, I think it's fair to say, in many respects, that circuit court is to an ALJ employment tribunal as an employment tribunal is to an unemployment tribunal, if you follow me. So almost without further ado, please bear with my terrible recording of my amazing interview with Attorney Victor Forberger. Thank you very much. Let's do it. All right. Well, hello again. This is Ben Hitchcock Cross talking to you today. I've got Victor Forberger. That's what we're going with, is Forberger, right?
Forberger. Kind of like Forberger's fries.
Perfect. Okay. Well, what we've got here is an interview of attorney on attorney here, and Victor is sort of on the forefront of a lot of issues here in Wisconsin employment law, particularly with regard to unemployment. You won't disagree with that, will you?
No. Myself and one other attorney, Brenda Lewison, are kind of the only attorneys left doing unemployment cases on a regular basis in the state of Wisconsin.
Okay. And, I probably do 3 or 4 unemployment cases a year, but only as, an extra part of some other lawsuit. In the same way that I might do a municipal court case or something like that.
And that's kind of standard in other states. So my background was I started my legal career in Massachusetts, and I worked for a year for unemployment hearings as an administrative law judge, and then I was a staff attorney, administrative law judge for the State Labor Relations Commission. And so I knew all the attorneys in Massachusetts and got to deal with them all. And it was very common for any kind of employment discrimination case or even union cases, if there was any kind of separation, that the attorneys handling the employment discrimination or the collective bargaining matter would represent the person at the unemployment hearing. Because the unemployment hearings provide this great way to, a first initial stab at what's going on in the case. Because
testimony under oath, and it's pretty quick, right?
Yeah. And so it was kind of very surprising here in Wisconsin that almost no attorneys, even those who handle employment discrimination cases on the claimant side, don't get involved at all in unemployment matters. So you're one of the few attorneys who is doing that, which seems to me is something obvious that you would be doing if you're a claimant rep. You get that first take at what the employers might be claiming or how the employer might react to various kinds of strategies or things you might do at the unemployment hearing. A great way to kind of test the waters, per se. That's just not happening here in Wisconsin.
Right, but when let's say we use it as evidence gathering, and I'm not usually thinking ahead to like the appeals court where I might be with some other claims.
Right.
Is that fair?
Yeah, but I think you can get information so you can kind of see, how is the employer going to react when you present evidence that, it's in this kind of way. If you react in a certain kind of style, will that cause the employer problems? How does the employer respond under pressure? And what are the claims the employer is making that might have no evidence, or that or that you think might be a problem for your client, the employee or the former employee now down the road. So it's a great way to kind of get an initial take at a lot of these issues. And I'm kind of surprised, like someone will have an employment discrimination case and they have an unemployment matter and they tell their client to call me up. And I'm like, I don't need to work because I've got enough unemployment people calling me up. And they're kind of, letting go of that kind of prime way to handle that employment discrimination case.
One other thing I really like about that is you get to sort of sandbag the employer, right? They don't have very much notice that you're coming. So, and a lot of times if I show up on the scene, they'll lawyer up, and then we don't get any good information from that point further. But with the unemployment ones, they're not really expecting us, so then we get different information.
Right. Yeah, there are. That's, again, it's a good way to kind of see what the employer actually is like.
Yes. And a lot of times I'll just add, I'll have a closely held company for unemployment for whatever reason, and you'll get the flavor of who you're negotiating with, right? Because you'll know if the owner's a hothead, if they're reasonable or whatever.
Yes. Yeah. You get all that kind of reactions right from. One of the difficulties, though, is now that all the unemployment hearings are done by phone,
Right.
you don't get any kind of in-person reactions. And
just as a general issue, how do you feel about that?
It's every attorney, employer and employee side, hates the phone hearing process. It's terrible. Though the employer side will candidly admit that it does have some advantages to the employer in that you can now pass notes around while people are testifying on the phone.
Right.
Because if the employer may have multiple witnesses on a case, whereas for the employee side, there really is just one witness, just the employee.
Well, I'll tell you, I have a difficult time not nudging a witness on the phone. It's just a physical reaction. reaction. I put my hands under my legs sometimes because it's just, it's a feeling.
And and part of it too is, with some of these newer, so I'm doing, for a while I was doing 1 to 2 hearings a week, minimum. And, so, and some of these administrative law judges really were not well trained. And so they were asking questions that just were kind of inane. And so if you were at an in-person hearing, the blank faces of everyone would kind of key into the judge, yeah, this is not a good question. But because it's a phone hearing, you can't get that. And the judge doesn't understand that. No one understands the question. And so, I mean, the client is looking at me, because we're in the room together. The client's looking at me, and I'm like, I'll shrug my shoulders and raise my hands because I don't know either what the question means.
I've had it where the ALJ clearly wants the hearing to be over, and the witness is just going on and on and on, but there isn't any cues for them to stop.
No. And that's the other problem too. I mean, when I was an administrative law judge, I used to, one of my signals to the attorneys, at least, that the testimony was going nowhere, especially when I was at the labor, because I'm not supposed to interrupt. Whereas unemployment, the administrative law judge there can take over the hearing. In a more formal proceeding, as a judge, you can't do that. So I would signal, I would start twirling my pen around and lean back in my chair, as opposed to when I'm, paying attention and taking notes and trying to follow the proceeding. So again, that's something you could only communicate when we're in person. The department has pushed the phone hearing process because it's much more administratively convenient. But it really does a disservice to the parties and to the unemployment process and to justice. And there's not even any kind of protocols or procedures in place to do in-person hearings now. So it's, so even if the parties lived in Milwaukee or lived in Madison, could easily attend an in-person hearing, it's just not available anymore.
Or I'll have the judges say you need a good excuse, at least at the Equal Rights Division.
So there's, they pushed the telephone hearings too. There are at least some protocols in place to still doing in-person hearings for employment discrimination for workers' comp. It's gone for unemployment now, which is the most ironic thing is unemployment 3 years ago or 4 years ago now. I mean, that's where all the hearings were happening. I mean, there were hundreds of hearings being done every day in unemployment. There might be an employment discrimination hearing occurring, 1 or 2 a week, and same with workers' comp. Now it seems to me the reverse is happening here. It's mostly because where the lawyers are most organized. So there are organized lawyers in workers' comp and in employment discrimination. So they've been able to push back and get some process in place for doing some kind of in-person hearings. There are almost no attorneys involved in unemployment matters. And as a result, it's there are in-person hearings.
Probably a good lesson for everyone everywhere. What do you think about Zoom hearings, though? Same opinion?
I just think that it's still very highly problematic. There's technological hurdles, and it may be a little bit better if, as a lawyer, I can organize that and set up multiple cameras and computers, so that and kind of control that setting. So making sure it's working, and then monitor it. So I'm protecting my client, but it's also putting a technological demand on attorneys to understand, their networking they're using, and monitoring that to make sure that those rights are being protected. I mean, there's a reason, like when we have court reporters who do their depositions by Zoom, and we pay extra for that because those court reporters are specifically trained to do all that, manage all that tech. And I'm not sure any of that training and protocols have been in place for the administrative law judges and then for the lawyers in doing all these hearings, these video hearings.
Right.
I mean, I had one of the cases I had with unemployment was a client who was mostly deaf, and she was mostly, heard stuff by reading lips. So the department kept trying to call her up to investigate her unemployment claim, and was bewildered why she wasn't answering her phone and talking to them. And so I had to.
Didn't they have the TTY or something?
Well, she doesn't use TTY. She's visual. And whether they use TTY is unknown because they didn't even offer that.
Right.
They just kept calling her up on the phone, and then I had to explain, no, she needs to communicate visually. And it ended up like to do the investigation, the person called me up, and then I had to then set up a video chat with my client so that she could read my lips. So I'd repeat the questions that the claims investigator was asking, repeat the questions to her so she could read my lips, and then she could answer. And then I would, and the adjudicator could hear the answer because I had the speaker turned up, so it would be heard over the phone. But that's, I mean, and of course the adjudicator denied the claim anyway. So then we had to do a hearing, and that was, they set up a video hearing. It was like a one-time special event to set that up.
Well, at least you had a good reason that time.
Yeah, but that's kind of and I'm the person that had to set that up.
Right.
The department provided a feed, but then I had to make sure all the technology worked. So this is,
It's a time tax, like nothing else.
Oh, it's also just kind of depending on technology. And I mean, the other major issue here is Wisconsin does not have online access in most of the states. I mean, I'm in Madison. You're in the Milwaukee area, right?
Yeah, I'm downtown Milwaukee.
So yeah, so we have good internet access. So it's, there's some monopolies going on and that kind of stuff, but at least we've got reasonably good internet access. I go out, 20 miles in either direction, and the only internet access I got is through my phone.
Right.
That's, how can you expect someone to do some kind of video hearing on their phone?
Yeah, that's not justice.
It's and then they got to pay for that data. So you're also creating a technological hurdle, but also a financial hurdle for some people because they, so a lot of people are they're paying per gigabyte, gigabyte, whatever it is.
Right. Well, whatever it is, if there's a barrier between them and the courts, I mean, it used to be that the government would try to eliminate those barriers. That offload.
Yeah, I'm not having any of that effort to kind of make these legal proceedings universal anymore. And that's a great observation there, is this whole push towards universality is gone. And
well, that's why we're talking here.
Yeah. It's frustrating from my end because I keep raising these issues, and it's, it seems like I'm talking in the wind.
Well, hey, the biggest case I've got going right now is that the Milwaukee County says my client has to pay for the transcript of the hearing before he can appeal it. And instead of fighting fair on that, they went to the judge and had a secret arrangement. So
is that for the appeals court?
Well, before at the circuit court level, yeah.
Yeah, you need a transcript to get to the appeals court. Is that it?
Sure. Yeah, but on cert, on review of decision, should the person who's seeking review have to pay to have
Yeah.
a transcript produced? Or should the person who made the decision have to produce their decision in a readable format?
Yeah, that's something else that's is new to me here. Again, come from different states. There is no oral argument. It's just an oral decision. And so, I arrived here in Wisconsin in 2008, and I got hired by a law firm representing a union. And we go in for this oral argument. And then I quickly realized the judge had already made up his or her mind and then proceeded to read a quickly written decision into the record. And part of it is what's going on is the courts are underfunded here in this state. I mean, this is my take on it now, is the courts are so underfunded that the judges don't have time and don't have the clerk staff to help them properly research and write these decisions. So instead, they quickly, dash these decisions off orally. And this also provides an incentive because all the court reporters here are independent contractors. And so for any kind of appeal, you then need to pay the court reporter for that transcript. So it's a way to, again, to subsidize these the court reporter process, as opposed to like if you had a regular process in place where the judges would listen to the arguments and then write a decision out through research. I mean, I would still want that transcript because there may be something that the judge said, but do I need that transcript right for the appeal? I'll need that transcript later when I'm writing my brief. So it's.
So I can tell you, I've been in the same situation, and probably for many of the same reasons. How did that affect your strategy going forward?
No, it doesn't, because I'm still trying to fight for these issues. So it just, and again, like most of my cases, in fact, well, pretty much if I'm in an unemployment case and I'm at the, circuit court appeals court level, they're almost all pro bono. Some are kind of a low fee. Like I'll charge a client maybe $100 or $150. So I have to, and I can't, technically my pro bono agreement would allow me to charge them the transcript cost, but I can't do that. I mean, just because, unless the client really, has the money, but most of my clients don't. So I end up eating that money, eating that cost myself. So, that's part of the frustrating part of my legal practice is I am making very little money because I'm just, I have all these basic costs that I incur that I can't charge my clients because they don't have the money to begin with, and there's no one else, there's no organizational presence involved in this area that's going to push this issue.
Why unemployment law is a tough road to hoe?
Yeah, it's at least like if I win an employment discrimination case, I get my attorney's fees.
Right.
So, and that's kind of what keeps my my employment discrimination cases, the few that I have. That's where I make my money. The unemployment stuff isn't helping financially, at least.
And then it's supposed to be 20%, right? That's the concept.
For unemployment?
Right.
No, 10%.
10%. Okay.
Yeah, it is 10%. Which, so like for example, I've got so one of the cases I'm involved in is this LWE administrative penalty. So the department has been charging people administrative concealment penalties for LWA benefits when they're charged with fraud. LWA is lost wages assistance.
Okay.
That was created by our former president back in 2020 when the pandemic unemployment compensation ended. That was a $600 supplement that people were getting. That ended at the end of August, and people were kind of, well, the pandemic is still going on. People need this money. And so the former president created this kind of emergency program out of FEMA money.
Okay.
So of $300 a week, and in Wisconsin, it turned out for the next 6 weeks, people got an additional $300. But that's FEMA money, not unemployment. And so you can't charge administrative concealment penalty for fraudulently received unemployment benefits when you don't have unemployment benefits to begin with.
Makes sense.
But the department did it anyway. And then I challenged them on it, and they said no. They came up with all these different rationales for why they could do it. Of course, the administrative law judge affirmed it. I appealed to the Labor Review Commission, and the Labor Review Commission reversed, saying it's not an unemployment benefit, so you can't do it.
And so when we're talking about unemployment, we're talking about Tony Evers' administration.
Well, I mean, hold on to that. I'll circle back to that. And now the Labor Review Commission said, no, you can't charge these administrative concealment penalties for LWA assistance. And the department has appealed those decisions now to circuit court in Waukesha County, even though the claimants don't live in Waukesha County.
So people from Australia might not know that Waukesha County is a fairly conservative county outside of Milwaukee, and that you're likely to get a more conservative judge than you would say in Madison.
Well, or anywhere else in the state, I think.
Yeah.
So, in one of these cases, it's about $120. That's it. $120. So, and this case will probably go, both these cases are probably going to go, I think the other case is $450. So there's almost no money involved, but there are thousands of people who got subjected to these penalties. And I'm not sure like what the department is thinking about. Does it mean that they'll have to reverse this and pay back all these administrative concealment penalties? Or are they just, so focused on collecting money out of claimants that they just feel they have to fight this?
Right, but there's fighting it, right? I mean,
well, but this is what
the choice to go to Waukesha.
and so that to me indicates that they really want to take this money out of claimants' hands and claw this money back. And it just seems for minuscule amounts. And so there's no way I could charge these, if I charge these people fees, and let's say, for circuit court representation, we're talking probably a couple $1,000s minimum for my work.
Yeah.
And I wouldn't, technically, I'm not subject to the 10% cap in circuit court. That's only before administrative law judges or for the Labor Review Commission. Who would pay me, $3,000 to overturn their, $450 fee?
I get it.
Yeah. So
We say there's some cases you just have to pay.
yeah. So this is just the nature of the beast. That so this case has to be pro bono.
Well, let's name some names here.
Oh.
Because who has the money first off? Do the claimants have the money or does the state have the money?
Look, the claimants received benefits back in 2020, 21, and the state's now trying to claw it back. And what we've seen is the states clawed back a tremendous amount. So I think, and one of the funds where all this money goes to, well, it goes into two funds basically. One is the unemployment trust fund that is already at 1.5 or 1.6 billion. So that's at this level it's supposed to be for the lowest income tax rate for employers. So we're already back.
$150 is a statistical non-entity.
Yeah. So that money, the $150, that actually goes to the program integrity fund, because that's part of this where there's administrative concealment money that goes to that fund. That fund is now at, as of June of this year, end of June, I think it was at 31 million. So prior to the pandemic, it was about 19 million. So it's jumped by over in the past 3 years, or maybe was at 9 million. I forget the numbers. It's gained at least 10 million, $11 million during this pandemic.
Presumably on his clawback.
Yes.
Okay, well, so that's a big deal.
It's a very big deal. It means they've collected a ton of money out of claimants' hands. And
unemployment does go to everybody in theories, right? So it's not a means tested.
No,
necessarily.
It's not any kind of benefit at all. It's an insurance premium that employers pay.
That's a good point. Thanks. Yeah.
So this 31 million that's in there now, that represents, I'll get a little technical here, the 25% of that administrative concealment penalties. So it's a 40% level right now. 15% goes back to the trust fund. 25% goes into program integrity. So when it's gotten let's say $10 million, that means, that was 25% of what they collected. So that means they collected actually 40 million in administrative, in unemployment benefits that they said was fraud. So that means $50 million they've clawed back.
And we don't know if they're all people in the same situation as your clients, but presumably a lot of those people just paid the money back.
Well, the collection efforts with the department are rigorous. They will intercept your taxes, they will garnish your wages, they will levy bank accounts. So people called me up and said, yeah, they just took $40,000 out of my bank account. I was, about to put it down for a house. I'd saved all this money, transferred to my bank account, and then the timing was terrible because it was when DWD implemented a bank levy, and they take everything but the first $1,000. So the person lost $39,900. And
that's okay. That's because what I'm trying to be clear is there's a decision being made to do this, right?
Yes, and all these, and it goes back to where's all this coming from government-wise?
Right.
There were huge changes that were implemented under the Scott Walker, when Scott Walker was governor. And those changes were not necessarily in the law. They made some changes in the law, mostly about job search efforts. And some changes in misconduct and added a substantial fault disqualification. But what we've seen in the data, and I've looked at the data, is people don't lose unemployment benefits because of job separation reasons anymore. You get laid off, and it's only about a 50-50 or maybe even a 33% chance you'll actually end up collecting benefits. Because the main reason now people get denied unemployment benefits is because they fail to satisfy the claim filing requirements. They get something wrong on their weekly certifications.